Hi, good afternoon, everyone. My name is Matt Fogelman. I am an attorney in Massachusetts. I handle a lot of employment cases representing employees and workers. I've been consulting with a lot of doctors during this time. I want to just thank all the medical professionals who are working so hard to combat COVID-19. Really appreciate everything that you're doing. This is not to be construed as legal advice. There's no attorney-client relationship. This is just general talk, question and answer, educational purposes. If you have a specific legal question, feel free to contact me and I can help you, or I can put you in touch with the right person.
And I'm going to be asking the questions. I'm Dr. Amy Fogelman of Medlaw Consulting. This is my husband, Matthew, who is handsomely at the camera. So the first question I'm going to ask is, the last video you talked about medical students and attending physicians who were salaried employees, but you didn't talk about residents or fellows. So can you discuss that a little bit?
Sure. So residents and fellows from an employment perspective are considered equivalent to a salaried attending physician. In other words, they have the same protections as those physicians that have completed residency and fellowship. So you're protected from discrimination, you're protected from retaliation. This is different than a medical student who still has some of those protections, but they are not necessarily employees because they are students, and if they have an issue, an employment issue, the first step that they would do would be to go talk to their school. If a resident or a fellow has an employment issue, if they're being asked to do something that they're not comfortable with, the same as a attending physician, they should register that issue ideally in writing by first going to their direct supervisor and also potentially going to human resources and also potentially contacting a lawyer.
Now, what happens if the residents or fellows feel like they're in an unsafe situation, such as not being given adequate personal protective equipment?
Right. So I would say, again, the same as a salaried attending physician. If you don't feel comfortable because of a patient safety issue or a personal safety issue, you should feel comfortable not to put yourself in that situation. In other words, you can refuse to participate in that. Now, if there are punitive or retaliatory steps that are taken against you, such as being terminated or being kicked out of the program, obviously that's not something that you want to happen, but I believe that you would have a strong legal claim in that scenario. Now, query whether you want to go down that road and be in that situation, but sometimes people have to make tough decisions about what they're going to do, and you may be in a tough situation. So ultimately you're going to have to listen to your own gut and your own self about whether you can or cannot do what's being asked of you. And again, I would also recommend just consulting with counsel before you make a definitive decision about whether you can or cannot do something.
Now, if I'm working, this is for an attending physician, if I'm working within my scope, for example, ICU is my scope, but I feel that patient safety is at risk because I'm covering 4 times as many patients as usual, what are my options?
Similar to the answer that I just gave, if you believe that, now this is again for a salaried attending physician, but if you believe that patient safety is at risk, at issue, in this case, you're being asked to see 3, 4, 5 times as many patients, and you feel that you cannot handle that, you feel that you are jeopardizing, that patient safety is going to be jeopardized because this is simply too much for any one person to handle, you should raise concern with your supervisor and or with HR, ideally in writing, and obviously ask for help, ask for additional staff to be put on the team. If you feel that you can ultimately handle it, then handle it. And if you feel that you can't, then you need to think very carefully about that. And again, talk to the right people, potentially talk to an attorney. You also may want to contact your state legislators. Different states are looking at liability issues in this crazy COVID-19 time that we're in. For example, there are some states that are considering essentially waiving liability, where they're actually going to pass a bill that says during this particular time, and that could depend on what time period, but during this time, medical professionals who are working on coronavirus issues would be immune from liability. In other words, would not be able to be sued if what they were doing was related to COVID. So that's another possibility.
Could you also ask the patients to sign a waiver?
There's been some talk about asking patients to sign a waiver. You certainly could. I don't think that's a decision that would be up to you. It would have to be something that you would discuss with your supervisor and really with your practice, right? So if you're working for a private practice or a hospital, it's something that would be most likely done on a practice-wide basis. It's a possibility, though. It's a possibility. The problem is that with waivers and things like that is you get into informed consent issues. What if the patient is really sick? What if they're incapable of signing it because they don't understand what's going on? So it's much trickier.
Mm-hmm. So somebody wrote about your last video. They said, it sounded like from your presentation that I have the right to refuse to perform tasks that I feel like would jeopardize patient safety and to use my own PPE if the hospital refuses to provide adequate standard protection. Is that correct?
I think so, yeah. And JACO has recently come out with some guidelines or recommendations about this. And yes, I would say that people should be free and feel comfortable using their own PPE if they don't feel comfortable with the PPE that is being provided by the institution. There's really no reason why you should not be allowed to. Particularly if the PPE that's being provided is insufficient.
Will quitting jeopardize my license?
Quitting under what circumstance?
That you were not, either you were being asked to perform tasks that jeopardize patient safety, or you weren't allowed to wear adequate PPE.
I see. And would that jeopardize your license?
Yeah.
I think it's kind of a state to state inquiry, and I don't want to speak to every state, but in general, I would say no, that it would not jeopardize your license if you had a legitimate patient safety reason and concern for what you were doing.
There were some questions about hazard pay. Can you say something about that?
Sure. So hazard pay is typically reserved for hourly workers, not salary workers. And in most times, it really would not be applicable to the medical setting because being a doctor or a nurse is potentially a hazardous job. As opposed to people who are working with, chemical waste and things like that. However, this is a very unusual time. We are dealing with a global pandemic that is coronavirus, extremely insidious, contagious. Doctors and nurses are obviously getting sick and unfortunately dying. And so I believe that this would qualify as a hazardous situation, and therefore hazard pay would be appropriate. You can talk to your practice about that. And again, I mentioned the legislature before, but it's something that you want to talk to your legislators about as well. And I would say also nationally in Congress, there is some talk about extending hazard pay, including to doctors, even if they're salaried. I would recommend you do some research on your own and find out who's supporting that and who's not.
So just to clarify, so hazard pay in general is only for hourly workers, or
Correct.
It's for other people?
Correct.
So it probably wouldn't apply to physicians.
It probably would not normally apply, but this is not a normal situation, and I think there are some practices who are going out of their way to provide that.
out of the goodness of their heart, it sounds like, not because they have to.
Correct. Exactly. Unless there's some legislative movement, whether that's state or state or federal or both, that would make it more widely applicable.
Got it. I've been asked to go on voluntary furlough and I don't want to. If I say no, could they fire me?
Yeah, I've been getting a lot of questions actually about these types of issues. People who are being asked to go on furlough, people who are being asked to have their salary cut, people who are being asked to have contracts amended. It's hard to give a catch-all answer to this question. I think the first thing I would say is, do you have a contract or not? If you have a contract, then the first thing to do is we have to look at the terms of that contract. How long is the contract? What does the contract say about how the contract can be amended? Does the contract talk about an emergency situation? Does it talk about a furlough situation? So look at the contract. If you don't have a contract, then, arguably, if you don't have a contract, then you're considered an at-will employee. The company, the institution has greater leeway as to what they can do and what they can't do, whether that be firing, not firing, furlough, whether that be raising salary, lowering salary. So first step would be to determine if you have a contract or not. Second thing would be, what does the contract say? Third thing would be, what are they asking you to do? Fourth thing would be, talk to an attorney.
So if someone was being asked to go on a voluntary furlough, but they had a contract that said that they had 90-day notice had to be given before they were let go, then they couldn't be fired for saying no.
That's right. And again, I've been facing that question a lot. So if you have a 3-year contract, the contract may have a sort of an out clause that might say something like, either party can terminate the contract with 60 or 90 or 120 days notice. So it's a 3-year contract, but there's this out clause provision. Either side has to provide, let's say, 90 days notice. So in that case, if the institution were to come to you on April 11th and say, starting on April 12th, you're going to be on voluntary furlough, or starting on April 12th, your pay is going to be cut in half. We want you to sign this document. I would say, no, you don't have to sign it, because the contract that you're under provides, in our example, this 90-day notice provision. So that is something that should either be negotiated, should be discussed, or again, consult with an attorney.
Is there any other trends you're seeing in the contracts that you're reviewing?
I mean, I mentioned a couple of them, salary reductions, hours reductions for people like radiologists and, ophthalmologists, like people who are not sort of on the front lines of COVID-19, salary reductions, hour reductions, furlough situations, being asked to practice out of scope. Those are, contract amendments or proposed contract amendments. Those are a lot of the issues that I've been asked to review. Non-compete agreements as well.
And how does a non-compete agreement affect someone during the coronavirus pandemic?
It doesn't necessarily, except for the situation where you want to leave your practice and you want to go to another practice or start your own practice. The non-compete that you have, if you have one with your current institution, has to be analyzed. What does it say? Does it give a time limit? Is there a mileage? Sometimes it says you can't work for another practice within 5 miles or 10 miles of your current practice. So again, it has to be carefully analyzed. And also, I would say, carefully analyzed against state law. Something may be in a non-compete clause that doesn't comply with state law, and it sort of slipped in there. So an attorney can advise you on what the non-compete law is in your state, and that's something that I can do as well, and then compare that to the non-compete clause and see if it matches up.
Is there anything else that you think that doctors should know about their employment situation while they're practicing during the coronavirus times?
I don't know that I have anything else specific to add. I think just, a lot of the things that we talked about today, and also in the first video, with respect to PPE, patient safety, your own safety, certainly. We mentioned OSHA last time. If you feel like your own safety is being jeopardized, maybe it's related to PPE, for example, you have the right to speak up about that. You have the right to file a complaint with OSHA about that, and you're protected from retaliation, if you do so.
So if anyone has specific questions, they can contact you. Do you want to let them know how to reach you?
Sure. Best way is my email address, mjf@fogelmanlawfirm.com. You can also look at our website, fogelmanlawfirm.com, Fogelman lawfirm.com. You can also contact Amy through MedLaw Consulting or through the various medical organizations that she's associated with.
And the Facebook groups.
And the Facebook groups, which I know a lot of you guys are part of, and it's great that exists for you all to keep in touch with each other and share ideas and best practices.
All right, thank you very much.
Thank you. Stay well.